My name is Desiree Yagan, and this is part 2 of the recording of October 6, 2006. Judge Langston McKinney, Desiree Yagan, pro se defendant, and ADA Geoffery Ciereck, who did not appear on day of jury trial.
In other words, a prosecution can't be lodged against you, and you can counter in a criminal case and say, no, put those bums in jail, if anybody. We can't use a criminal case for that purpose. Its only purpose is to determine whether or not you are guilty of certain conduct which violated the criminal law, the penal law of the state of New York. The things that you're talking about are much more readily and properly addressed in a civil case. You mentioned something about malicious prosecution. That's the kind of thing to be raised in a civil case. We have on the table here a motion by the people to dismiss this case in the interest of justice, where they've advanced a number of reasons that say, for all practical purposes, little if anything is to be gained by further prosecuting Desiree Yagan for this offense. And they've set those forth, I think, with a very high level of clarity. The incident involving the staple gun, there's no intimation that she was going to use it unlawfully. She has been involved in no criminal conduct since that date. The notion of bringing to trial all the witnesses who would have to testify in this case would create somewhat of an administrative nightmare. And for what it's worth, their bottom line, they say, we choose not to prosecute her. You win. No. Do you understand that? Yeah. You're involved in a boxing match with someone, and you say, well, and the one person decides they're not going to come out of their corner on the first round. Yeah. Okay? You can't tell me that the referee has a right then to say, no, you guys are going to get out there and fight because you've won. You've won the case because they're moving to dismiss it.
Your Honor, may I please speak?
I'm going to let you speak, and then I'm going to give you my decision.
Okay. Your Honor, I filed motions to dismiss before the district attorney's office. They refused it. Your Honor said I have not suffered. I have suffered tremendously. I've had to come into court. I've had to make
Ms. Yagan, that all comes up in your later lawsuits against the DA's office or your pending lawsuits about a course of conduct that they've followed. It has little or no bearing in a criminal case now, right now. Okay. Do you understand that?
No, Your Honor. Please, I have a right to speak, and I'm asking the court to please allow me to be heard on before it makes a decision as to let me say this, Your Honor. They were aware of all this. They prosecuted me since July of last year. They had no problem with this. Now they said, oh, now we're really going to trial. Now, that is malicious action. I understand I have a civil action. Your Honor, please let me speak. I understand I have a civil lawsuit against them. That's not the issue. The issue is this, Your Honor. If they prosecuted me up, let's say July, this is now November. They prosecuted me. Thank you, Your Honor. Let's see, July, August, September. Okay, 24 months. I don't know how. They prosecuted me for 24 months. They had no problem. Now when we're going to what happened, Your Honor, is it's just like the Stephen Powell's case. They have to be stopped. If they're going to prosecute, and I can put a memorandum for the court. I can't do this. That the court says that if the Court of Appeals states that the district attorney's office, if they're going to prosecute a case, they cannot try to leverage a person to accepting dismissal, and then when they don't, they say, oh, well, we'll just dismiss the case. That is criminal, but more importantly, the interest of justice demands, let them present their case. They said, well, gosh, gee whiz, we prosecuted Desiree, but now we're really going to trial. We couldn't pressure her and coerce her into taking a dismissal so that we get some sort of viable, credible appearance that there was something, a legal arrest for an inane staple gun incident. No district attorney's office, I submit to this court, would ever take the staple gun incident of this person who entered the courthouse routinely and always on business before the court, Honorable Judge Joseph Fakey. I'm saying to this court, Your Honor, that they prosecuted this for let's say, I'm not good with numbers, a year, 14, 15 months. They prosecuted me, and now they say, well, now look, it would draw a significant burden to jurors. What is my justice, Your Honor? I have a right to file federal, but that's not the point. I have
Ms.
a right
Yagan,
to be at trial.
if this case is dismissed today,
Yes, Your Honor.
you win. If this case is dismissed today, virtually every single thing that you're advancing to me, the dismissal supports perhaps that you may be entitled to some relief.
And
Deputies here arrested me, and the district attorney's office held onto this case until yesterday, and then they issued this letter when they know we're really going to go to trial.
All of that's a matter of record. It's
Okay.
fixed. It's fixed now on the record.
Okay.
You can do with it as you see fit.
Okay.
I've had a chance to consider this motion, and I concur with the recommendations of the DA's office that little, if any, interest of justice reasons would be served by further prosecuting you for these offenses. So I'm going to exercise my authority under Criminal Procedure Law, Section 170.30, Subdivision 1G, and dismiss this case.
Okay, Your Honor. Could you please repeat that?
It's all in the papers. CPL Section 170.30.
Oh, I'll get one of those anyway. I will have the official,
The letter memorandum. According to my copy, they said they sent one to you. Apparently, they may have mailed it, and you may not have gotten it. Maybe in today's mail or tomorrow's mail.
okay, go down to the clerk's office and get a copy, or can I be provided?
I just gave you a copy.
No, I'm not talking about this, the court's order right now.
I haven't prepared the order yet. You have to
Okay.
give me a chance to do that. I just granted the order, Ms. Yagan.
Okay, Your Honor.
I'll prepare an order and sign it. It'll be a part of the case here.
All right, Your Honor.
Now that I've dismissed the case, you can sit down.
I had to stand up. I got so much pent-up energy. I didn't sleep.
I understand that. Ms. Yagan, listen to me if you would. All right? I've been with this case almost from day one. And I understand some of the difficulties that you've encountered in the course of trying to have what you would consider a fair and just day in court. All right? And I can certainly understand some of the feelings that you have based upon my familiarity with the history in this case. I've been in effect being a little bit short-circuited, if I can say, by having the case dismissed. But you need to understand, I'm telling you this just as a matter of emphasis. A trial involves an tremendous expenditure of time. It's the probably most time-intensive way of making a determination of guilt and innocence. And if there's some factors about a case that say that the court, that the DA's office, that the defendant should utilize their time, energy, and efforts to devote it to something else, I don't think that there's a better case than this one that says it ought to be stopped.
But, Your Honor, they needed to do that.
No, just wait. No, listen to me if you would. One of the remedies that's available to you as a litigant is to have brought the motion yourself. Months ago.
Brought the motion for what?
To dismiss this case in the interest
I
of
no
justice.
longer wanted it dismissed. I made that motion a long time ago, and they refused it. And, Your Honor, after that, I said, if they're going to prosecute me and put me through this, then we're going to trial, and I'm going to prove before a jury that I'm innocent, and I will also implicate the deputies for falsely and maliciously arresting me, and I've been denied that. Your Honor, one last thing. The district attorney's office has a duty. They look at the charge, say, oh, is this credible? Is there sufficient evidence? It never met the sufficiency. They knew it, and they prosecuted me. That's malicious, Your Honor.
That's another time, another case, another judgment, Ms. Brady. I just want to close. I want to put the period at the end of the sentence and say the following. Good luck. Okay? Good luck. And a copy of the order will be in the file within a day or so.
Okay, thank you, Your Honor.
All right.
I do want on the record I object, but.
Well, I noted all that.
Okay, thank you, Your Honor.
All right. I'm off the record.